Good afternoon, Your Honors. Public Defender Lauren Sutter. I'm talking to Mr. Tatum, who is standing to my right.
Tatum scheduled for a hearing today, and this is for a violation of probation. Okay, looks like the violations alleged that you violated the amended order from November 18, 2024 for AgriHealth, that you failed to submit your random year analysis on January 5th, January 17th, January 22nd, February 1st, February 10th, February 22nd, and that you failed to complete victim impact panels. That's what he's pleading to?
Yes, Your Honor.
That's correct, sir. Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
Yeah.
Okay. Now, do you understand, sir, in this matter that you have the right to have a contested hearing?
Yeah.
Okay, you want to plead guilty?
Yeah.
Okay. Anyone threatening you to do that?
Yeah.
Any promises being made to you if you plead guilty?
Yeah.
What's the promise?
No. No. Yeah.
Thank you, Your Honor. Mr. Tatum, is it accurate that you underwent sentencing in front of Judge Simmons on June 17th of 2024?
Yeah.
And at that time, you were ordered to a term of probation.
Yeah.
And during that time, you were ordered to do random urinalysis or preliminary tests breath test free.
Yeah.
And is it true that on the dates the court has already read into the record that you did not submit for testing?
Yeah.
And you acknowledge that's a violation of your probation orders? Thank you, Your Honor. I believe that satisfies the factual basis.
Any questions from you, City?
On your honor.
The court is satisfied with the factual.
Right away, this isn't just about missing a few appointments. In probation cases, the court looks for a pattern of compliance. Every missed drug test, every skipped requirement, and every ignored deadline starts stacking up. Here's the big question. If you're asking for another chance, shouldn't your actions already show you're taking that chance seriously?
Basis, I'll accept your plea. Upon your plea, you may plead voluntarily and intelligently. I have a recommendation from your probation officer indicating that your attendance at community mental health has been inconsistent, and that your overall attitude seems good, but your progress is poor. Well, that sounds easy because it looks like November 18th, defendant pled guilty to violations. I said that he would serve 93 days Ingham County Jail to be held in abeyance if he had no further violations, and that he would enroll in outpatient substance use treatment, and that he needs to provide proof within 7 days, and that he would be testing 1 time per week for the next 60 days. And here we are. You can make allocation.
Thank you, Your Honor. I do acknowledge the time being held in abeyance from November 18th was something I was not aware of. I don't believe he had counsel on that, so there's nothing in our system noting that. I did talk to him today about the inconsistency and non-compliance with the testing. He fully acknowledges absolutely it is accurate. He's been inconsistent or non-compliant with the testing and victim impact panel. He was originally scheduled to complete the victim impact panel, and he acknowledged to me that work conflicted with it, and he chose to go to work when he should have chose to go to VIP instead. He acknowledges that's not something he should have. He should have reprioritized which one of those was more important. He did talk to me today about if the court does consider allowing him to continue on probation, that would be something he is prioritizing this week above all else. It's getting set up and scheduled for that victim impact panel attendance. He also did talk to me about the inconsistency of testing and acknowledged that's largely been a work and money issue. Told me he could test on Friday, has the money then, and knows that if he's missing any tests after this, that
The defense is trying to paint a picture of someone struggling with work, money, and family responsibilities, not someone intentionally ignoring the court. But judges hear difficult life circumstances every day. What often separates freedom from jail is whether the court believes you're making your court-ordered obligations a priority despite those challenges.
the court is coming down on him. He is asking the court to consider allowing him to continue on probation, knowing full well it would be an extension of probation if it was originally due to end on March 17th. And he would be asking the court to consider that in his behalf.
Where does he work?
I was working at Walmart, and then I was working at MSU. Right now, my assignment ended because I was working with him with MSU. Right now, going to call me for a power plant job, but I'm trying to get in A-list property management.
But when was the last time you worked?
Like a month ago now.
How is it that you're gonna use the excuse that you could not do what you were ordered to do as part of your probation because you had work?
I just taking care of the family. I can't provide for my family. I have to be there for my kids. My wife is working, and I have to want kids when she work. She works during the day.
Are you high right now?
No, I'm not.
Why are your eyes red and glassy?
Just waking up not too long ago.
You just woke up not too long ago? Because my courtroom reeks of marijuana right now.
Oh, it ain't me. You can come smell me.
I don't need to come over there and smell you. I can smell the marijuana
I
in
just
here.
came in the courtroom. You ain't
Okay.
smell it before I came here.
I sure.
And then the hearing takes a dramatic turn. The judge notices what she believes is the smell of marijuana in the courtroom, instantly shifting the focus from past violations to the defendant's credibility in real time. Whether or not it's connected to him, first impressions during sentencing can have a massive impact on how the court views everything else that's being said.
Didn't actually. I was sitting in here until they
I
opened the
don't
door.
smoke weed no more.
Okay.
I don't.
Okay.
I ain't smoked weed since I've been on probation.
Good. But I don't know that. You know why? Because you don't.
I don't.
You don't follow my orders. And if you think it's your responsibility to be out so you can take care of your children, then you would have thought it was your responsibility to follow court orders because you put yourself in this predicament. I did not. The court did not. The prosecutor did not. The public defender did not. And neither did the police. You took the actions that brought you before the court, and then you're not taking the actions to show that you have held yourself accountable and that you're willing to get on the right track. I give you a list of things to do and not very much things for you to do. You were supposed to engage in community mental health. You do it when you feel like it. You were supposed to be employed.
I've been going.
That's not what this report tells me. It tells me that's been inconsistent. You were supposed to go and complete victim impact panel, and I'm inclined to believe that was supposed to be within 90 days. You now are at a place where you should now be discharged, and I don't have it done. You know why I don't have it done? Because you had no intention of doing it. You want to do what you want to do. And you think that we want to sit here and continue to babysit you as an adult man. Why in the world would anybody property management hire you to do anything? You're not responsible. Why would they hire you? Based on what? You think if they see this video, they're going to want to hire you? Would you hire you?
That silence may have spoken louder than any explanation. When the judge asks, "Would you hire you?" she's not really asking about employment. She's testing accountability. In many probation hearings, showing ownership of your mistakes can be just as important as explaining how you got there.
No response? 30 days Ingham County Jail. To be served immediately. Who is this?
This guy right here. Let me get the keys.
You got the
Can you step out of my courtroom, sir?
You should have the key.
Yes, and that's not fair.
Hey man, go on, man. That's right.
I'm discharging his probation. I refer the balance. Well, I'm terminating his probation and referring the balance to collection.
And Aaron, can I ask, because the report I have is over a month old at this point, is the accurate balance still 472.11?
That's what I know. You still have that. Counsel, have your appearance.
Absolutely, Judge. Good afternoon. Jen Wilburn, P83143 for the plaintiff.
Okay, and ma'am, are Michaela Williams?
Yes.
Okay, today was the date that was set for a hearing. This is for a motion to set aside a default judgment. Ma'am, Ms. Williams, you defaulted by failing to appear for your hearing for an eviction proceeding. and you've now filed a motion to set aside that default judgment. In your motion, you indicate that you have different agencies seeking to help you, but that you also, you said your previous court date was under your acknowledged because you was told a different date for March 8th. Who told you March 8th was your court date?
Yes, in my meeting from the last court, whoever I
told you
met
that?
with, I don't remember his name, but he said March 8th. That's the date I had down when we had our
Okay.
breakout or whatever. I don't remember who I spoke with though.
What date did I tell you?
I believe March 8th as well.
I did not.
Okay, well, that's what I heard. Still, excuse me.
What date did
Yeah,
we
okay.
send a letter in the mail? With that same date, we mailed you a notice in the mail. It did
Yes,
not
ma'am, and I
come
did
back,
not get that. No, ma'am.
it did not come back to the court undeliverable.
Mm-hmm. Yeah, I didn't get it
And so,
though. That's why I didn't
oh,
appear because I didn't know it was under my acknowledgement. I didn't know anything about it.
Now we switch from criminal court to housing court, but the legal standard changes completely. To overturn a default eviction judgment, it's usually not enough to simply say you missed the hearing. You generally have to show both a good reason for missing it and a potentially valid legal defense. Missing either requirement can make winning the motion extremely difficult.
counsel, did you want to respond?
Briefly, Judge, it's plaintiff's position that there is no good cause or meritorious defense. Even if the court does find good cause based on the mix-up, there's not a meritorious defense outlined, which is required to set aside the default. So I would ask that the motion be denied.
I'm struggling with even with the good cause because I do landlord tenant hearings the same all the time. When I do pre-trials, I verbally tell you what your next court date is. So if you later go into a breakout room with someone and they say something different than what the judge told you, I would go back to the main courtroom and ask the judge, well, what you told me it was this date. What date is my court date? So that I make sure I have it accurately. That
Yeah.
never happened, ma'am. In addition to that, I know that I have a document here that tells me that you were mailed a note. And see, right now, even as I'm talking to you now, you're preoccupied with putting food in your mouth or whatever you're doing in the background. And that's probably why you can't pay attention. I'm telling you
Excuse
very
me, I'm at
important
work.
information. I
I'm at
don't
work, but
care.
yes, can we
I
continue?
don't care where you are. You are in
Ma'am,
court.
continue because I need to
No,
get
you
back to
are in
work. I
court.
need to get back to work,
You are,
so continue. I
well,
need to
get
get
back
back
to
to work,
work
so
then.
continue.
Your motion is denied. Your motion is denied.
Okay,
Bye.
y'all have a good day. The fuck?
What a contrast between these two hearings. One defendant lost probation after repeated noncompliance, while another lost an opportunity to reopen an eviction case after failing to convince the judge. Which ruling do you think was the toughest? And do you believe either outcome could have been different with better preparation? Let me know your thoughts in the comments.
Fuck y'all, bitch. Bitch.
Go pay your rent. You're all set, Ms. Cox.